Last time I was telling you about the instances where a contract with a minor becomes binding on the part of the minor. Now, what are all the cases where a contract with a minor will not be binding upon him? In fact, you cannot enter into a contract with a minor at all. I already told you, because minor is not a person under law. So, under what circumstances a contract with a minor becomes binding on him? I told you, in the case of necessaries. Necessaries means things which are considered to be indispensable. Food, clothing, shelter, etc., etc. I told you last time. And for any education imparted to the minor, Roberts versus Gray, that was a leading case which I explained and told you, any education which may be education on literature or even on games or the art of playing billiards and all that, these are all sports activities. When once it is actually imparted to the minor by a coach, it becomes binding on the minor to remunerate the person who has imparted that art or skill. Then I told you, it becomes obligatory on the part of the minor to discharge certain pious obligations and legal obligations. Now, what are all the instances under which a contract will not be binding on the minor? Definitely, a contract will become binding for necessaries and essentials, basic requirements, etc. A contract will not be binding on the minor in the following cases: where things that are supplied are found to be not necessaries. Second, where any loan that has been given to a minor will not become liable to repay the loan. Where if you want any accounts to be rendered by the minor and he has got to disclose the accounts, it will not be binding on the minor. So, we have got some leading cases. I will tell you about them. In fact, one of my students was asking me about the ruling that was given in the famous case Nash versus Inman. Now, let us succinctly summarize the facts of the case and analyze the law that is applicable to it. In Nash versus Inman, there was an Oxford University student, undergraduate. He placed an order with a tailor for stitching 11 waistcoats. So, the Oxford undergraduate student placed an order with a tailor for supply of 11 waistcoats. Probably that would have been the uniform that has got to be worn when the students attend the classes. So, these waistcoats were ordered by the minor. Subsequently, it so happened that the minor was supplied with enough waistcoats. So, he got it. You see, when once he placed an order, on the date on which he placed an order, he had no waistcoats. But before these waistcoats could be supplied to the minor after stitching, the minor was supplied with enough waistcoats. And the minor had enough waistcoats in his cupboard. Then, when the tailor supplied the waistcoats duly stitched, the minor said, he is not liable. He said he is not going to pay money. So then what happened? Whether the shopkeeper who has stitched the waistcoats on credit, will he be able to recover the money from the minor? Now the point is, the onus falls on the shopkeeper who is the plaintiff here. So what he should prove? The shopkeeper should prove that waistcoats are necessaries. See, it is necessary. Clothing, food, shelter necessary, we have already said. So whether waistcoats are necessary, then at the time when the shopkeeper supplied these waistcoats, whether the cupboard of the minor had enough waistcoats. So the shopkeeper was put under responsibility to prove that at the time when the miner placed an order for supply of 11 waistcoats, whether he had enough waistcoats at the time. And secondly, at the time when the shopkeeper supplied the waistcoats, whether the miner had enough waistcoats in his cupboard. There is an interregnum, the date on which the miner has placed an order for supply of waistcoats and the date on which the order has been executed by supplying the waistcoats to the miner. In between the interval, it so happened that the miner had enough waistcoats that had been delivered to him. Then the shopkeeper was asked to prove by the court at that time when the shopkeeper supplied the waistcoats, whether the miner had possession of waistcoats, whether he had enough waistcoats in his cupboard. The shopkeeper was unable to prove. Therefore, the court said, anything that is ordered by the miner must be necessary not merely at the time when the order is placed, but also at the time when the order is executed. So in this case, the tailor miserably failed because he could not actually prove that at the time when he delivered the waistcoats, the miner had no waistcoats in his cupboard. On the other hand, the miner had enough waistcoats in his cupboard and therefore the shopkeeper could not supply. Therefore, the term necessary, as I have already been telling, it is a relative term. It must be necessary not only at the time when the order has been placed, but also at the time when the order has been executed. So this aspect one should remember. That is the ruling that has actually been given in the famous case Nash versus Inman. Now let us take up the question. A contract with a miner is either valid or void, and it is not voidable. In other words, under what circumstances a contract with a miner is considered to be void? Now let us enumerate one after the other the salient points. A contract with a miner will not be binding on him in the following cases. As I have already explained, anything that has been supplied to the miner which was found to be not necessary, when it is not necessary, then it is not binding on the miner. If anybody wants to prove a contract to be binding on the miner, the owner shifts on him and he must prove that the thing that has actually been supplied to the miner, it is necessary. That is why the shopkeeper failed in the famous case Nash versus Inman. It is not a question whether waistcoats are necessaries or not necessaries. Waistcoats are necessaries, no doubt. But at what point of time it becomes necessary? It must be necessary not merely at the point of time when the order has been placed, but also at the time when the order has been executed. Here the shopkeeper failed, and he failed to succeed in his case because he was not able to prove at the time when he supplied the waistcoats, the miner had no waistcoats in his cupboard. In fact, the miner had enough waistcoats. That is why the shopkeeper could not succeed. Therefore, now let us enumerate one after the other. Number one, anything that has been supplied to the miner which are found not necessaries. Now, any loan that has actually been given to a miner cannot be recovered because loan that has been given on a promissory note or under any agreement is considered to be void. And thirdly, the next important thing is anything for which the miner has to account for it, it will not be binding. You cannot file a suit against the miner for accounts. You cannot ask accounts from the miner for monies which you have lent. Therefore, let us explain one after the other. Now, in one case, Valentini versus Kenali, in that particular case, what happened? A miner wanted to take a house on rent with furniture. He has fixed the rent at 100 pounds. And therefore, the miner took that house with furniture on rental basis. And the miner paid 68 pounds in cash. And for the balance amount, the minor executed a promissory note. Then, when the minor never paid the balance, namely on the promissory note, the amount that is due and payable to the house owner when he not paid, the house owner filed a suit on the promissory note. Then the court held, you cannot enter into a contract with a minor. A contract with a minor is void. Therefore, the minor will not be liable for payment of money on the promissory note. And the minor also insisted that he should get back the 68 pounds because the house owner has actually deceived him and made him to enter into a contract, which was not agreed by the court. But the court said that the owner of the building need not return the 68 pounds which has been given in cash by the minor, because the minor had the benefit of enjoyment of that rental house. He was residing in that house, and not only for residence, but also he has been using the furniture for a considerable period. Therefore, the rental charges got adjusted in respect of that 68 pounds which has been given by the minor by way of cash. But as regards promissory note, the court held it is not valid. Well, I would like to tell you the facts of the famous case Mohori BB versus Dharmadas Ghosh briefly. Now, in this case, a minor wanted to borrow loan, and therefore he approached the moneylender for borrowing loan. The moneylender, as usual, asked the minor to give some property by way of security. Fortunately, the minor was possessing an immovable property, which he agreed to give by way of mortgage to the moneylender. Therefore, it was proposed that moneylender should advance to the minor a sum of rupees 20,000, out of which 8,000 was advanced by the moneylender, namely the mortgagee, by way of cash. Now, the minor had the benefit of enjoyment of that 8,000 rupees. And thereafter, 12,000 rupees alone had to be repaid by the minor to the moneylender, which he has secured by way of loan on the property, on the immovable property. Now, the question is whether this money should be repaid by the minor, or whether the mortgage deed, is it binding on the minor? That is considered to be the predominant question. To the surprise of the moneylender, the minor, he actually gave a shock to the moneylender by saying that the mortgage will not be binding upon him. On the other hand, the minor said that he was actually deceived by the moneylender, namely mortgagee, by inducing him to execute a mortgage deed in respect of that particular immovable property. Then the question arose whether the mortgage that has been executed by the minor, is it binding on the moneylender? Now, the matter went up to the court. The court has got to decide whether the mortgage that has been executed by the minor in favor of the moneylender, is it binding on the minor? That is why we say generally the question is asked whether a contract with a minor, is it valid or voidable or void? A contract with a minor is either valid or void, and it is not voidable. This particular aspect has been elaborately discussed in this case. No doubt the mortgagee filed a suit against the minor. The matter came up before the court. The court was convinced about the facts of the case, that a mortgage has been executed and the minor had the enjoyment of that 8,000 rupees that has been given by the moneylender by way of cash, and the balance has to be paid by the minor. Then the court said whether this contract is binding on the part of the minor. It was argued by the moneylender the contract with the minor is said to be binding because he has borrowed the loan. He had the enjoyment. But this balance 12,000 rupees was yet to be advanced by the mortgagee. 8,000 rupees has already been advanced. But thank God, the guardian of the minor cautioned the moneylender, look here, moneylender, don't give that money to the minor because it will not be binding on the minor. A contract with a minor is considered to be invalid. That is what he cautioned, on account of which, fortunately, the moneylender, namely the mortgagee, never advanced that 12,000 rupees to minor. Then the salient question that was posed before the court is whether the contract with the minor, can it become voidable? Now this is a case where the minor retracted, has gone back. The minor contended it was the mortgagee who induced him to enter into a mortgage and wanted to snatch away the property. With that intention, he made the minor to execute the mortgage and all that. He came up with that particular story. The mortgagee has to advance balance 12,000 rupees. The guardian of the minor cautioned the mortgagee, namely the moneylender, that the person who happened to borrow money from the moneylender is a minor. And therefore he cautioned the moneylender, namely the mortgagee, not to advance the balance sum of 12,000 rupees. Then the mortgagee got alerted. Then it so happened that the minor filed a suit against the mortgagee, namely moneylender, that the mortgage is not binding upon him and he was induced to enter into a contract with a mortgagee to give his property by way of security. Therefore, the matter went up to the court. Then the court has to decide whether the mortgage executed by the minor, is it binding upon him, or the minor has to pay the money due and payable to the mortgagee. Namely, already the mortgagee has advanced 8,000 rupees to him. Therefore, has it become payable? And the minor actually insisted he need not pay that 8,000 rupees. And furthermore, he said that balance 12,000 rupees should be given to him because he has already mortgaged the property and he has yet to receive that 12,000 rupees from the money lender, namely mortgagee. Then the matter was taken up by the court. Before the court, the main question that was posed was the fact whether the mortgage is binding on the minor. In other words, we should put it on a broad basis, whether a contract with a minor is either valid or is it void, and whether it is voidable also. The court said a contract with a minor is not valid. Then it was argued by the money lender, a contract with a minor is voidable. That is how he argued. He actually referred section 64 of the Contract Act and said, inasmuch as the minor has now come out with a case that the mortgage is not binding on him, therefore he has rescinded. Therefore, any money which he has already received by way of cash from the money lender, namely the mortgagee, has got to be returned to him under section 64, because a contract with a minor is said to be void, because he has got the option. I will read the section. You will find that a contract with a minor is said to be voidable. That is what he argued, for which section 64 was actually cited, and it was actually found when a person at whose option a contract is voidable rescinds it, the other party thereto need not perform any promise therein contained in which he is the promisor. The party rescinding a voidable contract shall, if he has received any benefit thereunder from another party to such contract, restore such benefit as far as may be to the person from whom it was received. The moneylender mortgagee was arguing before the court, section 64 will squarely apply. He said the minor has rescinded the contract, he has got the option to rescind it. Therefore, whatever benefit which he has already received, namely 8,000 rupees, when once the contract is not being performed, then it has got to be returned to the money lender, namely the mortgagee. The court said a contract with a minor is void under section 64. it is not voidable, it is void. Then immediately, if that is so, then section 65 will apply. Then he drew the attention of the court and said, section 65 will come to his rescue. Under section 65, when an agreement is discovered to be void, when a contract becomes void, look here the wordings, when an agreement is discovered to be void and a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it. Therefore, it was contended by the moneylender mortgagee that, look here, Your Honor, you have got to see that the minor returns that 8,000 rupees which he has already borrowed from me, in as much as it has become void. The court said a contract with the minor is either void, in other words, a contract with a minor is neither it is valid nor void, nor it is voidable. It is ab initio, it is void. A contract with a minor is not only void, because you cannot enter into a contract with a minor, and it is not voidable. And another thing is, section 65 says you cannot even enter into an agreement with a minor, because agreement itself becomes void. Section 65. A contract with a minor, neither there can be a contract nor you can enter into an agreement. A contract with a minor, ab initio, it is void. You cannot even enter into an agreement with a minor, because minor is not a person. So the court has decided a contract with a minor is either valid or void, and it is not voidable. Then the moneylender said, at least on equity principles, you have got to order, the money has got to be restored to me. He said, you knew pretty well the person who has borrowed from you is a minor. Knowing fully well that he is a minor, you have actually given that money. Therefore, you cannot get back that money. Any amount that is given by way of loan to the minor cannot be recovered, because he is not a competent person. Therefore, a contract with a minor is not binding for loan which he has borrowed. Next important point that we have got to bear in mind is, there is no estoppel against a minor. What is estoppel? If a minor makes a representation that he is a major and he cheats the moneylender or shopkeeper and borrows money or purchases articles on credit, how far it will be binding on the minor, how far it will be how far the shopkeeper will be able to succeed, or the moneylender will be able to succeed to recover back the money which he has lent and the articles which he has supplied to the minor. That is a question. Now, let us analyze the situation under three circumstances. Number one, where a minor misrepresents himself as major and purchases articles on credit or borrows money on credit. Number one. Second, where the appearance of the minor misleads the shopkeeper or moneylender, where a minor looks like a major in his appearance, and supposing a shopkeeper or a moneylender is actually misled by the personality of the minor. The third instance is an extreme case where the shopkeeper and moneylender, they knew pretty well that this minor is only a minor, and actually make him to give a statement as if he represented before the shopkeeper that he is a major and wanted to actually get these articles on credit. Now, that is an extreme case where the shopkeeper deliberately makes the minor to give a statement as if the minor has represented himself as a major. Now, these are the three circumstances. In all these three circumstances, there is no estoppel against a minor. What do you mean by estoppel? That means if a minor either stated in so many words that he is a major, if he has misled the shopkeeper by his own false statement, if he has said that I am a major and the shopkeeper was actually made to believe that he is a major on account of the statement that he has made, and he has actually supplied the articles, in which case also when he files a suit, the minor can still plead minority as his defense. Even though he has stated falsely that he is a major, even then there is no estoppel against a minor. But the minor will be held liable under criminal law, because you see, the plea of minority can always be used as a shield, but not as a sword. A minor can actually make use of his minority to defend the cases against whom any case has been filed. In other words, if any case has been filed against a minor, he can defend himself by saying that I am a minor and that minority will be used as a shield. But minor cannot take law in his own hands and make use of his minority in order to exploit others, in order to actually steal any articles from others by using minority as his defense. And when if a minor has actually pickpocketed any money from another man's pocket, and when a suit is filed that under a criminal magistrate court, and the minor cannot say, no, I am a minor, I am not liable. The minority cannot be used as a sword for stealing properties from others' pocket. Therefore, the plea of minority can always be used as a shield, but not as a sword. Then the next circumstances is where the shopkeeper has been misled by the appearance of the minor. Even in this case, there is no estoppel against the minor. The shopkeeper should have been diligent as a businessman. He should have verified whether the person who appears before him, whether he is a major or minor, what is his background, and that too when he is going to sell articles on credit, he should have definitely verified the creditworthiness of the person who appeared before him. There also, there is no estoppel against him. The third extreme case is a case where the shopkeeper, knowing fully well, he obtains a statement from the minor as if the minor has stated that he is a major. In all these cases, there is no estoppel against the minor.